Hello everyone, I'm Ankit and you're watching StudyIQ IAS English. In our today's video, we are going to talk about the most notable judgment ever given by the Supreme Court of India. That was the judgment given in the case of Kesavananda Bharati versus State of Kerala of the year 1973. Now, the notes that I will be using today in this particular session, in case if you want to download them, and you should because these are important for your exams, you can go to this particular Telegram channel, ATS Live. And while you're in this channel, you can download the notes and please do not forget to subscribe to it also. So let us start by understanding the context of our today's discussion. Now, this judgment, that is the Kesavananda Bharati versus State of Kerala case, the judgment which came in 1973, more than 52 years has passed for this judgment. And this judgment was notable because of many different factors. First of all, this judgment redefined the relationship between Parliament of India and the Constitution. Whether Parliament of India has the power to amend the Constitution, and yes, if it has the power, then how much can it amend the Constitution? This mystery was solved by this particular judgment. Similarly, this judgment was also very notable. First of all, this case was heard by a constitution bench of 13 judges, which was unheard of up till in 1973. Now, a constitution bench is any bench of Supreme Court which consists of at least 5 judges and they deal with matters of constitutional importance. Now, this judgment came with very thin and narrow margin, that 7 judges were in the favor of this judgment and 6 judges give a dissenting opinion. So this constitution judgment held that the Parliament of India has the power to amend the constitution, but it cannot touch the basic structure of the constitution. So this was the judgment, basically the crux of the entire judgment. But since we are going to cover a detailed lecture, let us understand what are the factors that led to this particular case. That is very essential if you have to understand the nitty-gritties behind this judgment. Okay. Now let us try to understand the background. Now, this situation emerged in the state of Kerala. You need to understand at the time of 1969, from 1957 onwards, Kerala became to be ruled by Communist Party governments. And this was the first ever government, not just in India, anywhere, which was a democratically elected government of Communist Party. Now, naturally, when Communist Party came to power, it brought many legislations to improve socio-economic equality of Kerala, one of which was introduction of Land Reforms Amendment Act of 1969. And this Land Reforms Amendment Act of the Kerala government, it allowed the government to authorize acquisition of any private property, which also meant the property of the sect of which Kesavananda Bharati was the head of. So theoretically, this Land Reforms Act allowed the state government of Kerala to procure any and acquire any private property, including the private properties of religious denominations. So this was the background of the problem. Now, naturally, I told you, the sect in question was Ednir Mutt, and Ednir's Mutt head at that time was Mr. Kesavananda Bharati. So Kesavananda Bharati naturally possessed some of the important lands which also fall under his name. So naturally, he became opposed to this decision of the government by passing the Land Reforms Act. So this Land Reforms Act, which was brought by Kerala government, caused Ednir Mutt to lose a significant portion of this property, which added to the financial difficulties the Mutt was facing at that time. So naturally, the Mutt and its head Kesavananda Bharati decided to challenge this act in the court of law. Now you need to understand at that time, Kesavananda Bharati was represented by one of the important legal doyens in the Indian legal history, Mr. Nani Palkiwala. So they decided to file a writ petition in the Supreme Court. Now, naturally, if you have understood the part 3rd of the Constitution that provides for fundamental rights, it also provides you the right to constitutional remedies under Article 32. Now, this Article 32 says that in case of violation of any fundamental right, you can directly approach the higher courts, that is the High Court and Supreme Court of India under Article 32 and under Article 226. So according to Kesavananda Bharati, this Land Reforms Act of the Kerala government violated his right to religion under Article 25 and 26, and most importantly, it violated his fundamental right to property, which at that time was fundamental right under Article 31 of the Constitution. So in cases of violation of this fundamental right, Kesavananda Bharati decided to approach Supreme Court using his right to constitutional remedy, which is provided under Article 32 of the Constitution. So this was the background of this issue. Now the most important provision of the constitution which you have to understand before we move forward is Article 13 subsection 2 of the Indian Constitution. Now this says that the state shall not make any law which takes away or abridges any rights which is conferred to any person under part 3rd of the Constitution, which is basically the fundamental right. And if there is any law passed by the legislature which contravenes Article 113 subsection 2, it would be declared void by the court of law to an extent that it violates your fundamental right. So naturally you'd imagine that any law or any amendment passed by the Constitution, by the Parliament itself, would fall under the provisions of Article 13(2). But in 1973, this was not the case. If you remember the previous notable judgments of Supreme Court, most importantly Shankari Prasad versus Union of India case of 1951 and Sajjan Singh versus State of Rajasthan case of 1964, these two cases highlighted that Parliament of India had unlimited power to amend any part of the Constitution. So these two judgments, again, which were given by Supreme Court of India, were very notable. It said that the Parliament's power to amend the Constitution was unlimited. So according to these judgments, the Supreme Court highlighted that Parliament of India has two kinds of responsibility. First was legislative responsibility. Using its power under legislative responsibility, Parliament of India can pass any law or statute. And if this law violates any fundamental right, then according to Article 13 subsection 2, they will be declared as null and void by court of law. So this was legislative power of Parliament. But in this judgment also, the previous one, Shankari Prasad and Sajjan Singh case, the Parliament of the Supreme Court of India, it also highlighted that in addition to legislative power, Parliament of India was also vested with constituent power. And according to constituent power, Parliament of India can amend any part of the Constitution. And even if it violates your fundamental right, then also Article 13 subsections 2 is not applicable on any amendment done by the Constitution, by the Parliament of India. So according to Sajjan Singh case and Shankari Prasad case, Parliament had unlimited power to amend any part of the Constitution. But all of this changed in the year 1967 when Supreme Court came up with the judgment of I.C. Golaknath versus State of Punjab. In this judgment, what was notable that the Supreme Court of India held that Parliament cannot amend the fundamental rights. So therefore, Parliament said that the Supreme Court of India said that Parliament has power to amend any part of the Constitution but not fundamental right. So from earlier position of Supreme Court, which highlighted Parliament had unlimited power, this judgment tried to limit the powers given by the Parliament. So this in a way checked the powers given to Parliament by limiting its jurisdiction that it cannot amend the fundamental right. So this was the precursor of whatever happened with Kesavananda Bharati in Edinir Mutt. So naturally, after the judgment of I.C. Golaknath case, the government of India at that time decided to nullify this judgment by bringing a series of constitutional amendments in the Parliament. The most notable was 24th Constitutional Amendment Act, which was introduced at the time Indira Gandhi was the Prime Minister of India. And this amendment stated that Parliament can amend any part of the Constitution, which also included amending the fundamental rights covered in Part 3 of the Constitution. This was not it. Government also introduced 24th Constitutional Amendment Act in the Parliament, which stated that yes, right to property is a fundamental right and it is creating problems in land acquisition, right? So let us remove this right to property as a fundamental right. So this was done by 25th Constitutional Amendment Act. And later on, in 1972, when 29th Constitutional Amendment Act was introduced, the government decided to insert the Kerala's Land Reforms Act in the Schedule 9th of the Constitution. If you remember, if any legislation is included in Schedule 9th of the Constitution, it makes them immune to judicial review. So judiciary can't review any act which was introduced in 9th schedule. So these were the series of amendments government introduced to nullify what? To nullify the judgment given by Supreme Court in I.C. Golaknath versus State of Punjab case. The most important here is 24th Constitutional Amendment Act and 25th Constitutional Amendment Act. Okay. Now, When Kesavananda Bharati filed his writ petition in the Supreme Court of India, he gave certain arguments justifying his writ petition. He stated that Parliament could not amend the Constitution because it does not have unlimited power. It has only limited powers. And it used the minority judgment given in Sajjan Singh case. Sajjan Singh case, the majority judgment highlighted that the Parliament has unlimited power to amend the Constitution. But one Justice Madhulkar, in his minority opinion, he stated that there are certain principles called as basic structure of the Constitution, which is beyond the prerogative of Parliament's authority to amend the Constitution. And this was the reason used by Kesavananda Bharati to justify his position that yes, Constitution can amend anything, but it can't touch the fundamental rights, which is the basic structure of the Constitution. In addition to that, he also stated that yes, right to property at that time was fundamental right under Article 19(1) subsection F. And what's the point of giving any fundamental right in the Constitution if you can't ensure its continuity? So if these rights in future is removed by the Parliament of India, does this make it a justifiable act? According to Kesavananda Bharati, this was not, which was the original intention behind fundamental rights. Why do we call rights as fundamental? Because these are guaranteed by the fundamental law of the land, Constitution. And in future, if you decide to remove it, what's the point of making it fundamental? So this was the argument given by Kesavananda Bharati to support his writ petition, which they have filed in Supreme Court of India. Now, the respondent in this writ petition was again the state of Kerala. So state of Kerala also justified their position. First of all, they stated that at that time, India followed the principle of supremacy of Parliament, which meant Parliament, which is a body upholding the people will, it held unlimited power to amend the Constitution, which included the power to amend the fundamental right. And it stated that Parliament should exercise this power in order to achieve socio-economic obligations which are provided in another provision of the Constitution, that is Directive Principles of State Policy. Now, according to Government of Kerala, there was prevalent inequality in India at that time. So in order to reduce this inequality, the government tried to undertake land reforms so as to ensure socio-economic equality in India. So this was the justification given by the Kerala government. First of all, Parliament had unlimited powers to amend the Constitution, including amending the fundamental rights. And to fulfill another objective, that was the objective of achieving socio-economic equality, given in DPSP, Directive Principles of State Policy, the government introduced land reforms to reduce inequality in access and provision and holding of lands in India. So this was the contention given by the state of Kerala. Now let us summarize what was the issue in front of Supreme Court before it considered, heard and gave the judgment of Kesavananda Bharati case. First of all, the Supreme Court of India had to decide whether 24th Constitutional Amendment Act, which stated that Parliament has unlimited power to amend the Constitution, including amending the fundamental right, was it valid or not? Second question in front of Supreme Court at that time was whether 25th Constitutional Amendment Act, which allowed for removal of right to property as a fundamental right, was it valid or not? The third question in front of Supreme Court at that time was that if Parliament has the power to amend the Constitution or not, and if yes, it has the power to amend the Constitution, then to what extent or how much can it amend the Constitution? This question was also to be decided of Supreme Court in this particular judgment. So let us understand what was the judgment given by the Supreme Court in this particular case. Now, the most notable thing Supreme Court did, that it balanced the considerations of both the parties in the state. It stated that yes, Parliament of India, according to the powers given in Article 368 of the Constitution, it has the power to amend the Constitution. However, it limited this power. The Supreme Court stated that this power is not unlimited and there are certain basic features in the Constitution of India. According to Supreme Court, they gave this name as basic structure. And the Parliament of India does not have the power to amend this basic structure of the Indian Constitution. And according to Supreme Court in Kesavananda Bharati case, basic structure or certain basic features of Constitution included rule of law, included separation of power between various organs of the government, and included fundamental rights of its citizens. So according to Supreme Court of India, in Kesavananda Bharati case, the Parliament of India does not have power to amend the fundamental rights. And why does not it have the power to amend the fundamental rights? Because fundamental rights constituted what was known as the basic structure of the Constitution. So in this regard, let us try to understand what is this doctrine of basic structure. Now, this doctrine of basic structure basically tells you that there are certain values, certain objectives, and certain provisions of the Constitution that constitute the soul, that constitute the basic structure or basic fundamentals of the Constitution. So, it is the prerogative of the Parliament not to change this basic values and basic essence of the Constitution. And if Parliament decides to take away these basic essence, decides to amend anything relating to basic structure, then the judiciary has the power to strike down that law as unconstitutional void. So this is what doctrine of basic structure means. I'll repeat it again. There are certain values, objectives, and provisions in the Constitution which makes or which provides the Constitution its very soul. So yes, Parliament has the power to amend the Constitution, but it does not have the power to amend this soul of the Constitution. Otherwise, if they amend it, the entire nature of the Constitution would change. And if Parliament misuses this power of amending the Constitution, then judiciary has the right, under the indirect power given to it for judicial review, to strike down those constitutional amendments. So this was doctrine of basic structure. Now let us understand what's the point or what is the significance of this doctrine of basic structure. First of all, it protects the fundamental values and principle which defines what is India's constitution. So this doctrine of basic structure basically ensures that Constitution remains true to its original spirit and intent, which the Constituent Assembly originally wanted our Constitution to be like. So any future government should not decide to amend this basic essence of the Constitution. And another thing that this judgment or this doctrine ensures that it prevents arbitrary constitutional amendment done by any ruling party in the future under political pressure or political compulsion. So this prevents political demands that might arise for any democratically elected government in the future to amend the Constitution, which might take away the basic essence or basic characteristics of the Constitution. Similarly, I told you, this doctrine tried to strike a balance that yes, it provides you a kind of flexibility to the Parliament to keep on changing the Constitution despite for meeting any future needs if necessary, but it also maintains a certain kind of rigidity that yes, necessary constitutional amendments are allowed, but you have to ensure that you do not undermine the fundamental or basic essence or basic principles of the Constitution, right? So this is the importance of basic structure. But this does not mean that this doctrine of basic structure has not been the subject of any criticism. There have been multiple criticisms of this doctrine. First of all, or the first criticism that comes to my mind is that this doctrine of basic structure limits the amending power of the Parliament of India. Now you have to understand, Parliament of India, it represents the sovereign will of people of India. So if the sovereign will, which allowed for formation or drafting of the Constitution, in future this sovereign will might also demand the government to make changes or amendments in this Constitution. So this might not be permissible entirely if we follow doctrine of basic structure. So this is the first criticism this doctrine of faces, that it undermines the need or it undermines the sovereign will of the people. Second criticism this faces, that now judiciary has the power of judicial review of any amendment done by the Parliament of India. So in this case, judiciary now acts as a constitutional watchdog over any amendment done by a popularly elected parliament. And this is done despite the fact there is no clear constitutional provision allowing the judiciary of India, particularly Supreme Court of India, to have this kind of power. So this basically means that this is an example of what? This is an example of judicial overreach. The third argument that many critics highlight criticizing the doctrine of basic structure is that judiciary in India is not at all elected. So they do not have the accountability towards the people which parliament does have. So what kind of authority and non-elected judiciary has to overrule what a democratically elected parliament provides? So this means that there is a lack of accountability of judges, which is not the case as far as the accountability of popularly elected MPs and MLAs are considered, right? So this is the third criticism. First was it undermines the sovereign will of people. Second criticism, that it is an amount of judicial overreach. And third, that since judicial members are not elected in this India, this basically means they are not accountable to people of India. The another criticism that this doctrine faces is that the term basic structure is a judicial innovation. It is not defined anywhere in our constitution. So basically, this doctrine heavily depends on subjective interpretation of judges. What if a judge in the future makes a vague interpretation of what makes or what provisions are constituted as basic structure, right? In Kesavananda Bharati cases, they only enumerated 3 principles as basic structure. In later judgment, they enumerated some principles. But what's stopping judges in the future to include many other provisions in the basic structure, right? Basically, this would mean that those provisions are immune from constitutional amendments. And another feature is that India's founder, or another criticism is that India's founder envisioned a living constitution. Now, a constitution needs to be flexible so that the needs of the future, be it socio-economic or political needs of the future, can be satisfied by amending the constitution. So if on one hand, you're inhibiting the parliament's ability to amend everything in the constitution, so this basically means your constitution is not entirely living, or it is not entirely dynamic, right? So this is the another criticism. Now, one more criticism I have in mind is that the instances of how the judiciary has used this doctrine of basic structure. Now, many argue, I'm not arguing it, many argue that the judiciary has frequently used this doctrine of basic structure to ensure that judiciary remains independent from other organs of the state. The most notable example is that when the Supreme Court of India invalidated the 99th Constitutional Amendment Act. Now, if you remember, this 99th Constitutional Amendment Act introduced National Judicial Appointment Commission, an appointment commission which was responsible for appointing members of higher judiciary, and it constituted 3 members from judiciary and 3 nominees from the government, including the law minister. And the Supreme Court of India held that this was unconstitutional and void, because when you include members of the government in appointing of judiciary, it violated the principle of judicial independence. So using this reason, the Supreme Court of India invalidated the 99th Amendment of the Constitution. And when you see the usage of this doctrine in other kind of cases that involve socio-economic policy or reservations, the Supreme Court has not used this doctrine of basic structure at all. So many say that this selective application of this doctrine of basic structure has led to a perception, it has created an image that this doctrine just shields the judicial power more than to strike a balance for national and socio-economic prerogatives, right? So this was the criticism of doctrine of basic structure. Now, I also have 2 PYQs that I'm going to give you today, but before that, we have something important that we need to tell you. Now, this topic that I picked up is a very important topic of Indian polity. If you want to study Indian polity in depth, the best option for you right now is to take admissions in one of our courses. Right now, we are taking admissions for our October batch, which is going to go until tomorrow, that is 5th of November, right? So if you want to get enrolled in one of our batches where we teach not just polity in detail, but economy, geography, history, all the subjects that are important from your UPSC exam from the perspective of prelims, mains, as well as interview. So everything is covered as far as GS is concerned in our P2I foundation batches. Now, these batches are available for 2027 and also for 2028. If you want to get admissions to these batches, please hurry up. They will close tomorrow, that is 5th of November. And if you use this code ATS Live now, you'll get maximum discount. So you'll be able to save as much as 7,000 rupees if you apply this code ATS Live. So please save your money, get yourself enrolled in one of the best courses that are available in this industry. You'll get clear about every detail. Now, let us try to solve this question. Consider the following statement. The Constitution of India defines basic structure in terms of federalism, secularism, fundamental rights and democracy. The second statement, the Constitution of India provides for judicial review to safeguard the citizens' liberty and to preserve the ideals on which the Constitution is based. Now, this question appeared in 2020. I'd want each and every one of you to solve this question and give me a correct answer in the comment section below. If you answer it correctly, I'll give your comments a thumbs up. Please do read this question properly. This is a tricky question. Now let us try to solve another question. We adopted parliamentary democracy based on British model, but how does our model differ from British model? As regards with legislation, the British Parliament is supreme and sovereign, but Indian power or the power of Parliament in India to make any legislation is limited. This is correct. As I've told you, what we infer from our today's discussion, India's parliament has wide powers, but it does not have unlimited power. It is restrained by doctrine of basic structure, judicial review, separation of power, etc., etc. In India, matters relating to constitutionality of the amendment of the act in parliament are referred to constitution bench by the Supreme Court. This is also correct. So both of these statements are right and we have to identify the correct statement. So option C is your right answer. So I have solved this question for you, which is from 2021. But I'd want each and every one of you to solve this question, right? So please do let me know the correct answers in the comment section. What do you feel about this doctrine? Students, I want your comments in the comment section. Is this doctrine justified? Has it allowed our soul of the constitution to be retained, or has it inhibited the ability of parliament to amend the constitution based on socio-economic and political needs of the country? What do you feel about this? Please do let me know in the comments. And once again, if you have to download this video, you can go to this particular Telegram channel where it will be available. In case if you have problems in locating it, this is the QR code you can also scan. So I'll take your permission. Please have a very good night.